State for the Home Department.
Yes, Mr. State.
Good morning, my lords and lady. Before I commence, I should say I've had a short discussion with Ms. Giovanetti, and it would seem that I might be able to shift the advocacy timetable to a short degree, that I have another 15 minutes after lunch and 15 minutes less tomorrow possibly, but I'll see how far I get through my speaking note.
Well, you are aware, of course, that this is the third time round this particular block for actually all the members of the court, one way or another, and it's the same constitution as heard MM Lebanon and SS Congo and sundry other cases. And so we are pretty familiar with the material in your written case, which of course was extremely full. So bear that in mind in the course of your submissions. I'm sure Ms. Giovanetti will do the same because she's been here before, but we appreciate you haven't.
Yes, no, of course, my lady. I hope to not turn to too many authorities, but at the same time provide you all with references and MS numbers.
Thank you.
My lords and lady, of course, I appear on behalf of Ms. Agyarko and Ms. Ikuga. Ms. Giovanetti and Mr. Sheldon appear on behalf of the respondent. These are linked appeals concerning, of course, further leave to remain as partners of British citizen sponsors. The applications were refused on the basis, first, of the immigration rules not being met, and thereafter, in terms of the statutory residual discretion, on the basis of proportionality, as the guidance would have us understand. In both cases, of course, there is a consideration of EX1, so I will turn to that briefly during the course of my submissions. The key convention right, of course, is Article 8 and the right to respect for that family life, which is another important factor in terms of the submissions I'll address you on today. So I don't intend to repeat much or hardly anything at all of what's said in my written case, but I will address you to a large degree on issues that have come about in the respondent's case, such as the positive versus negative obligation and things of that nature or variation. Before we begin, in my humble submission, it's important to reflect why we are here, and I say that's because the binding authorities of the House of Lords of Razgar, Wang and EB Kosovo have not been directly applied, we would say, in the underlying appeal before the court below. We say that's a clear violation of Young versus Bristol Aeroplane, as stated in our written case, but it would be for the Secretary of State to persuade this court that those hallowed judgments are now wrong and no longer to be followed. Notwithstanding, it's also said that there is a clear and constant jurisprudence of the Strasbourg court, which perhaps overtakes those matters or corrects those matters, it seems.
My recollection is that Ms. Giovanetti was not seeking to persuade us that certainly Huang was wrong on our previous canters around this particular course.
Well, I may be wrong in my understanding. Of course, I'm sure Ms. Giovanetti will correct me on that if I am.
She says in her present case that Quiller may need some revision, I think.
Yes, that is stated in very plain terms. That, my understanding, would be because of the departure from Abdulaziz and the positive versus negative obligation that is laid out there in paragraph 68. I will come to that momentarily, but I say that would involve a reflection of what paragraph 67 says first, before turning to 68, where the obligations are laid out. If I may, I will briefly embellish upon my submissions in my written case concerning the rules, as it is an important underlying factor to the alleged democratic approval given to the rules and guidance that were laid before Parliament. Although I say and guidance, it's all part of one collective system of analysis. But it's important to reflect the guidance, of course, was not placed before Parliament. It's only the statement of intent, compatibility, and the rules themselves. So looking at the rules, and I'm aware, of course, that the panel have already heard a lot of submissions on this point, I will, if I may, give a few bullet points before moving on. We say the rules are statements of practice. We also say they're a weak form of scrutiny and don't represent democratic approval. That is, submission is made good in the following way. In terms of the constitutional importance of the rules, I would ask the panel to note that the authority which the Secretary of State places some firm reliance upon of Nagare in the administrative court, which is said to be upheld repeatedly in the Court of Appeal, does say at paragraph 25, and I won't ask you to turn up the paragraph itself just now, the immigration rules do have some degree of democratic endorsement. We say that is wrong because of the fact that the statement of intent, for example, discusses that there is a codification of human rights, a complete codification, it would seem on its face, or at least that is the impression given to Parliament when the paper was laid.
And does this, I don't understand this point about democratic approval. I know it's sort of spoken about, but surely the point about the rules, they're made by the Secretary of State under statutory authority in pursuance of her constitutional responsibility for immigration, which is basically what Alvey says. And, frankly, the extent of any debate in Parliament is not really something we can go into. It's really more the matter of the statutory authority which the Secretary of State has.
Well, my Lord, the submission that the Secretary of State pursues, which we say is untenable, is that as a result of paragraph 17 of Wang and Lord Bingham's observation regarding Kay versus Lambeth and perhaps the lack of debate in terms of Parliament assessing these rules and what are the terms and conditions of immigration control, could perhaps, if it is debated, give more force to the legislation and thereby calibrate or give greater weight to the public interest.
I mean, he's there distinguishing it from statutory approvals, such as you have in Kay. But of course, that was a particular time of the Kay debate, which of course again moved on. So,
my Lord, I would agree firmly with that, but it would seem that the Secretary of State's underlying reason or rationale for laying these rules and codifying the fundamental right of family life is to, it would seem, take advantage of that observation of Lord Bingham, that there is something perhaps that can give greater deference to the public interest, and thereby we can make a move back towards.
Well, there are two different aspects, aren't there, about the sort of democratic constitutional element in this debate. One is, of course, if Parliament has expressly debated and considered and approved something, varying depending on whether it's primary legislation, secondary legislation, not legislation at all, etc., etc. But the other, of course, is that the person who's got the statutory authority to make these rules, these statements of practice, is herself democratically accountable to Parliament. So that's the other part of the argument, which I'm sure Lord Bingham would have been very alive to, that when ministers exercise statutory functions, they are accountable to Parliament for the way in which they exercise them. So it's not just that Parliament may or may not have debated these things, it is that the minister can be held to account by Parliament for what she has or hasn't done. I think there's both of those aspects. We're not going to get too hung up on it, may I say, because the real point is what is the status of these rules, what do they mean, how should they be applied, and what does the rest of the law say, and how should that be applied. Those are the points.
I'm grateful, my lady. In that event, I won't detain you too long with this topic.
Sorry, I'm speaking merely for myself. If any of my lords disagree with anything that I have said, they will shout.
Well, it's very much a secondary issue, isn't it?
Yeah.
I say it's not. It's a secondary issue. I agree with that, but I wouldn't say it's so far removed that it wouldn't require some extrapolation by the court, because a great deal of debate and discussion has been pursued in the lower courts and the upper tribunal as to what degree the public interest should be weighted and given deference, according to the Secretary of State's submissions time and time again. So this is a fairly important principle, which is the reason why I am addressing it, but I will do so in short order.
Well, one thing you can say, sorry, we're busy interrupting you all the time, but that's because we're very engaged in this subject, having spent such a long time on it already. But one thing you can say is that clearly in all of these cases, the individual's interests have to be weighed against the general public interest. It's always a great deal easier for a court or a tribunal dealing with an individual case to see the strength of the individual case, and rather harder to see the strength of the public interest. And the person who is responsible for policy in relation to that public interest is therefore entitled to have a view about it. And the courts have to take that view into account. That's,
Absolutely.
Well, my lady,
But that's made pretty clear by Lord Bingham and Wang.
yes, exactly. That's what he was talking about.
my lords and lady, that is precisely what the appellants would argue, but that is not the practice that is followed on a day-to-day basis at the first tier and the upper tribunal of the specialist chamber. What happens is that one doesn't necessarily get to a proportionality assessment because the rules are said to be, by the particular representative of the Secretary of State, the be-all and end-all, and it's only if you can show something exceptional.
That position has been disavowed, at least to some extent, in the earlier cases. And therefore the question for us is, whatever claim is made for the rules as a charter of all of the considerations that have to be taken into account in relation to Article 8, that has not been the position that the Secretary of State has taken in the earlier cases to which my lady has referred. And therefore it does seem to me you want to concentrate, while not neglecting this point, you want to concentrate your fire on the capacity of the rules to deal satisfactorily with all of the considerations that a personal evaluation, or an evaluation personal to the individual, demands, rather than get too much deeply embroiled in the question of whether or not these have constitutional legitimacy and how that enhances their status.
It may also, if I may say so, be important for you to focus on the fact that yours is an application for judicial review of a particular decision, rather than a challenge to the rules as a whole. And the terms of the decision may not reflect quite the same approach to the rules as has been adopted in recent hearings on behalf of the Secretary of State.
My lords, that may be, but if the position adopted has been retreated from by the Secretary of State, that would surely affirm my position even more and show that my complaint, as it were, on behalf of these appellants that the...
Well, it may or may not be. The only point I'm making really is that in a judicial review, the court's focus is primarily on the decision under challenge.
Of course. Well, I do propose to analyse the rules, as it were, against the applications, but if I may, I'll just give a few MS reference numbers then and tabs as to what I would ask the panel to look at in the context of these very then extremely brief submissions, which I will skim through or skate through, if I may. I ask that the panel look at the statement of intent at paragraph 34. The volume number is 1 tab 9, and the MS number is 194. That is in the context of the rules giving weight, be given weight by parliamentary debate. I also ask in the same breath that the panel note 17 of Wang, and also that the panel note paragraph 40 of the statement of intent at MS 194.
Sorry, the statement of intent, you mentioned 2 paragraphs.
Yes, I did. That, my lady, the first one was paragraph 34, and the second is paragraph 40.
Yes,
Both on the same page.
yes,
Yes, my lord and lady.
yes.
I say that those paragraphs and the analysis, I would ask the panel to find that the rules do not have the approval of democratic imprimatur, are echoed by the upper tribunal at paragraph 32, and that is to be seen at volume 5, tab 57, and the MS number is 1756. I should say in relation to the MS numbers, I've only had a few hours with the authorities.
I think paragraph 34 is in fact MS 203, 203.
In the upper tribunal, Mr. Stanley, which of the decision?
That sustains the analysis of the statement of intent and the lack of democratic approval of the rules.
The paragraph number?
32, Roman 1 and 2.
32, thank you.
Of Isuazu.
Yes, I was going to say, I assumed that you were going to take us to Isuazu. or at least you were going to rely very heavily on the upper tribunal's analysis in Izuazu.
I do, my lady. I say it's an authoritative and scholarly exploration of the rules shortly after they came into force. It was very much hot off the press, as it were, and the President was very much apprised of the change or shift in dynamic from an open-ended and open-textured residual discretion that the Secretary of State might employ, contrasted with a very strict and prescriptive rule followed by guidance, which doesn't allow much room for exploration and fetters the discretion effectively.
Yeah, I'm sorry, could you give the citation of Iswazi again, please?
The full citation, my lord.
Yeah, well, no, the MS.
The MS number I canvassed was 1756. I'm
756.
conscious it might be the first page.
1766 is the page of the paragraph to which you wish to refer.
I'm grateful, my lord.
1766, paragraph 32. Discussing the status of the immigration rules.
If I may, my lords and lady, I would briefly ask you to also look at section 3.2 of the 71 Act for a particular reason, not one which has already been canvassed by the previous appeals. That is to be found at volume 1 of the authorities, tab 1, MS 15.
MS
15, 1-5, my lady. (3.2) is fairly straightforward. If it's to hand, of course, then I'd ask the panel to look at it briefly. We are all familiar with this subsection, but I would emphasise a particular point, not the fact that they are statement of rules and practice to be followed, but from the second large paragraph of 3.2, if a statement is laid before either House and is disapproved by a resolution within 40 days, then the Secretary of State will make changes or further changes as appear to be required. So it's clear from there that regardless of democratic approval, allegedly, there are no changes that Parliament can, of course, suggest, because it's entirely at the discretion of the Secretary of State how she will exercise immigration control. But more importantly, I also place reliance in my written case on Lord Hope's judgment in Stellato, and that appears at volume 2, tab 19, and the MS number is 682. And that is at paragraph 12 of the judgment. It's a fairly mundane paragraph, except that it throws into stark relief a very interesting issue in terms of the rules themselves and the manner in which they are promulgated or laid before Parliament.
Which paragraph of the judgment, please?
Paragraph 12, my lord.
Thank you.
So the
687.
that's MS 682.
687.
Oh, 687.
Paragraph 12 is at 687.
I do apologise.
Don't worry. We can cope.
I'm grateful, my lady. As we can see from the paragraph, it starts with an exploration of affirmative resolution. About 6 lines or down or so, it moves to the negative resolution procedure. Is a less rigorous form of parliamentary control. It's laid before both houses for a period of 40 days. The next sentence is, I say, crucial. It takes effect on expiry of that period unless it's been defeated by a resolution annulling or praying. The point I make here is if the rules are laid on the 14th of June 2012 and they come into effect on the 9th of July 2012, that's 26 days in which there's been alleged parliamentary debate and full scope for praying or moving a motion to annul or say the rules should not be followed. So I'm not making a case here that the rules are unlawfully passed. I'm simply highlighting that there isn't a full purview, as it were, for parliamentary debate in both houses.
What were the dates you just gave us?
So the rules were laid on the 14th of June 2012, and as they say on their face, and in fact happened, they came into effect on the 9th of July 2012.
Thank you.
Which is a period of 26 days, as opposed to the 40.
So within the 40 days that Parliament allegedly had the opportunity of saying no. But the previous point that you made, which I think is, if I may say so, an extremely interesting one, that even if Parliament does say no, it's entirely up to the Minister to decide what to do as a result.
Yes, my lady, perfectly, because the Secretary of State is in charge of control, as it were, and it's at her entire and utter discretion that the rules will be passed or laid, as it were.
Rather dilutes the point about ministerial responsibility that I was putting to you earlier, doesn't it?
It does, my lady, yes.
I see what you're saying.
Apologise, I'll pause one moment I don't want to cover ground that may have already been covered. There are several paragraphs of Alvi that I was going to direct your attention to, but instead I think it would be more sensible to give you paragraph numbers and MS numbers as far as they may be accurate. So Alvi is located at volume 3, tab 31. The MS number for the starting page is 1062. I apologise, I don't have all the MS numbers for the paragraphs I'm about to refer to, which are paragraphs 23, 35 and 36, 37, 39, and 41. In brief order, what those paragraphs discuss are that during the course of those 40 days, a scrutiny committee may examine the rules, and they, of course, if it is an important piece of immigration control that's being laid, will produce a report. There isn't any comment or any sight of a report thus far in the cases of both parties, from what I understand also of the appeals in the previous matters. So in other words, there would not have been a comprehensive legal assessment report produced for the benefit of members of Parliament who may not understand the fairly complex nature of Strasbourg and domestic jurisprudence on Article 8. 35 and 36 cover that topic as well as 23. Moving from there, 37 and 39 show that the idea of parliamentary control over the rules is false or hollow for the reasons I've just said, which is that the minister in charge has the final word, as it were, on the immigration rules. They cannot be amended unless she agrees. Finally, as is said at 39:41, it's for the courts to act as guardians, as it were, of the protection of the fundamental rights of the Convention. But it's important, as 41 says in its last sentence, that external documents can be called for, such as guidance, particularly where it's referred to so excessively in the rules from time to time. But the guidance on this occasion doesn't appear to have been called for and therefore wasn't scrutinised. So members of both houses would not have had any idea of the prescriptive terms of the guidance, which I will turn to shortly. Another important distinction, I say this more from my day-to-day interest in the tribunals, is the point made in Alvi and Odalola that the rules create legal rights, therefore they are important. That is completely wrong now. The rules do not create legal rights anymore, and that is illustrated by Section 84 of the Nationality, Immigration and Asylum Act 2002, and that appears at Volume 1, Tab 3, and the MS number is 55. I say this moreover also because I understand that Lord Carnwath posed a question as to the importance of the legal rights created by the rules in one of the previous appeals. So it's interesting to note that, forgive me, my lady.
Were we not, these are not appeals, these are
They are not,
reviews,
they're not.
But one of the cases, other cases that we've had have been appeals, and has this section not been amended by the 2014 Act?
Precisely.
Which is not relevant to any of the cases before us.
It's not relevant to the cases before you, but it's important in understanding the new system of immigration rule challenges that are open to applicants
Well,
and the
rules-
weight to which they...
I mean, in this appeal, we're dealing with a pre-2014 Act world. Otherwise, we'd be looking at a different version of the rules as well.
My Lord, it is pre-2014, but in terms of understanding the erosion of rights which we complain of, it gives context and colour to my submission. I won't delay you for more than a sentence or two, my Lord. All I sought to say was that under the new regime, one can only appeal an immigration decision on the basis that it is in violation of Section 6. That is important because it presupposes that the rules are beyond challenge or question other than judicial review and, for example, proceedings such as the present. So we will see more of such proceedings if applicants or appellants such as my clients say that the rules do not reflect or carry out a proportionality assessment as they should do. So, for example, the not in accordance with the law right of appeal that previously existed under Section 84, which is the reason why so many appeals may have come before the Court of Appeal and the House of Lords, no longer exists. It has quietly been swept away, and there is no way of challenging the rules other than by Wensbury grounds. So I say that's important because in terms of appeals, consideration by courts, the courts will only now be able to consider whether a decision violates Section 6. The rules themselves are beyond remit except by Wensbury rationality, which is a fairly important basis to understand. I will move on swiftly. I'd also rely upon Quiller, of course.
Sorry, can I just be clear?
Forgive me.
Your reference to this page is irrelevant because this is an amendment which postdates what we're talking about. But your point originally was that the rules don't create rights.
Yes, they do not create rights any longer.
But that's post-2014.
It is
As far as
post-2014.
this appeal is concerned, they still do create rights.
They did at that time, yes.
Thank you.
But there was no right of appeal anyhow. So we are here.
Yes,
But
would you just clarify that? There was no right of appeal against the particular decisions that we're concerned with in these two cases.
yes,
Am I right in thinking that were the decision not to be respected and so the person not leave and then removal directions were given, that there would be a right of appeal at that stage or might be a right? The letters say may be a right.
only after, and I'm sure Mr. Giovanetti will correct me if I'm wrong, after I think the 6th of April 2015, had the decision been made then when the Immigration Act 2014 brought in rights of appeal for human rights decisions as long as they were not certified as clearly unfounded.
Well, I'm only interested in what the position was in relation to these
Then no, they would
two
not have-
claimants at the time that the decisions were made. Their decision letters say there is no right of appeal against this refusal of leave. It goes on to say, so make your arrangements to go, but if you don't, the Secretary of State will take action to ensure that you go, words to that effect, and then there may be a right of appeal. That's what it says in the letters. So I'd like to know what that right of appeal was. Maybe Ms. Giovanetti can help us in due course.
It might be helpful if we had a copy of Section 82 of the 2002 Act as it stood at the time of the decision.
Incidentally, Ms. Giovanetti, you have a rather important person in this case who's sitting 2 rows behind you.
A very important person.
Well, why doesn't he sit on the row behind you so that A, he's got something to write on, and B, when you need his advice, you can turn and ask him for it?
Very sensible suggestion. If
Well,
I
I
may
thought
say
of it
so.
last time, but didn't. But of course, it wasn't apparent. But it's now completely apparent who that gentleman is, and I think he should be sitting behind
Yes,
you.
I think last time space was at a great
Space
premium.
was at a premium. This is right. Yes,
I should invite Mr. Peck over. Move forward. Thank you very much.
it is our normal practice that that those who are most closely involved in the case should actually be sitting close to those whose mouthpieces they have.
Well, more than a mouthpiece, but
Oh,
I went to the defence.
much more. Sorry, Mr.
My lady,
Saini,
I'm
but-
grateful. I would say that there was no right of appeal under the previous Section 82.
There was or there wasn't?
There was no right of appeal.
Yeah.
There would not have been one. There is no removal decision. I understand. My lady, Ms. Giovanetti is highlighting that. Your question was whether, if there was a removal decision, there would have been a right of
Yes,
appeal.
that's what I was asking about, because that's what it says in the letter.
There may have been at the discretion of the Secretary of State.
No, you can't have a right of appeal at the discretion of the Secretary
Well,
of State.
it's
That is
the
a contradiction.
discretion of the Secretary of State whether to issue the removal decision or not.
Oh,
There was a great deal of there were a great deal of judicial review claims in the administrative court and the other tribunal challenging the Secretary of State why she would not issue removal directions, and she dragged her feet and consistently would not do so. So it's questionable whether she even would have done so, whether it would have required another judicial review to seek a removal decision to gain that valuable right of appeal anyhow.
whether she was required to do so or elected to do so when she issued her removal directions, was there then a right of appeal?
Yes, my lord.
Yes.
There was.
That's Section 8, that's the old Section 82, isn't it?
It is.
It's very it's dangerous just to try to remember it, but that's my impression.
That is correct, my lord. My lords,
And of
moving...
course, at that time, if there was a breach of the immigration rules, that was a ground for a successful appeal. If you were entitled, under the rules, you were entitled, irrespective of whether Article 8 was in play at all.
Yes, that was ground A.
Yes.
Yes. Yes, my lady. Before moving to the rules and the guidance themselves, the final point I would ask is that the panel note, if it is relevant, which of course I leave at the court's discretion, the extent to which the margin of appreciation is canvassed by the new rules and the extent of deference required to be given to them by courts. The authority I rely upon is Connors versus the United Kingdom, which is located at volume 6, tab 63. The paragraph is 82. The MS number is, for the starting page again of the judgment, is 2095. I apologise, I don't have the particular page to hand.
Paragraph 83.
82, my lord.
82. That's it.
Essentially, there's a passage I rely upon there that the margin will tend to be narrower where the rights at stake are intimate or key rights. I would say naturally it follows that family life is an intimate or a key right. It fits both parameters.
It's MS 2116.
MS 2095.
2116.
Oh, so forgive me, it's 2115. I'm grateful, my lord. Moving to the rules and the guidance, we would argue that the consideration given to EX1B, which is the, as it were, the synonym for insurmountable obstacles under the rules, does not reflect Strasbourg jurisprudence. The Secretary of State's case is heavily weighted upon that submission, that Strasbourg jurisprudence pervades the entirety of the rules. However, when one looks at EX1B, as we shall, that clearly does not follow. A first example of that is if one looks at what Rodriguez de Silva does, and if I may put a short submission first before turning to it in detail. Rodriguez de Silva makes it clear that in the Strasbourg court's historical jurisprudence, if there is someone who has a precarious status, then of course you may look at insurmountable obstacles as a factor, but it's just a factor. It's not the be-all and end-all. It's not the test. It's just a consideration amongst all the other laundry list of factors that can be considered. So the submission is already there in the written case that it's elevated to a test, but the point I would also highlight is that it doesn't just apply to precarious migrants under the rules. It applies to potentially all migrants, and I say that for an important reason. Under section ELTRP of the immigration rules, and this is located at volume 1, tab 6, which is HC 194, it's the statement of changes themselves, so it's the relevant rules at the time. And I should say the reason I'm referring the court's attention to this tab as opposed to what's described as Appendix FM is because the Appendix FM that appears behind that tab is the current version as opposed to the version in force at the time. So as we're in a judicial...
Where do we have the version that applied at the relevant time?
That's in this tab, tab 6 of volume 1. I found it within HC 194, as it were, the introduction of the new rule. So the MS number is 121 through to 124. It is quite a difficult read, if I can be polite to the draftsman. But essentially what it is a list of what are termed as eligibility criteria which must be met by any migrant, whether they are settled or non-settled. Otherwise, if not met, you're treated as a precarious migrant.
Treated as a
Precarious migrant, because you must go to EX1B to be given any leave at all. So the eligibility criteria, in short order, are maintenance, accommodation, the English language requirement, very mundane but important things. So, for example, if someone enters the United...
Paragraph of ELTRP are we invited to look at, Mr. Saini?
It should appear... Give me one moment. Give me one moment, my lord.
This is all about...
Yes, it's in... sorry.
It's all about partners, isn't it? We're not talking
It
about
is.
everybody, we're just talking about partners.
My lady, possibly not. The paragraph in question it actually appears above ELTRP on page 30, MS 134. It is at RLTRPT 1.1, the requirements, forgive me, not 1.1, where are we?
what, 134?
Forgive me, my lord, I'm trying to find the
That's apparent.
relevant one.
Well, partner, as you said, starts at page 121, and we see the financial requirements at LRTP 3.1, and we see the language requirements at LRTP 4.1. So, but I don't see what the parent has to do with it in page 134.
What's the point you're making, Mr. Saini?
The point I'm making, my lord, is that if one doesn't meet one of the eligibility criteria, I was using a hypothesis that if someone does enter according to the rules, their spouse makes, for example, £18,600. Supposing there are a cut in the working hours, they make less money than that. If they don't meet one of these criteria, then it will be that the eligibility criteria are not met. Therefore, you have to show EX1, A or B are met in order to have a grant of leave within the rules. That is the manner in which the rules operate, that if you don't meet one of the criteria, you're automatically categorized as EX1A or B. You need to show that it's reasonable not to leave for the child or reasonable for the British citizen partner not to relocate abroad. So it's fairly harsh is what I'm trying to show. But it's a fairly simple point I wanted to turn to first before turning to the bones of the argument. So we would say that the test, for example, in EX1B, where it discusses British partners, presumes, and I would underline that word, that British partners will relocate abroad and continue their family life. Now, there may be various reasons why the Secretary...
I'm awfully sorry.
I do apologise. I'm directing my...
EX1 assumes what?
EX1B assumes or presumes that the British partner will relocate abroad. The manner in which the rules are...
Well, if they're to stay together.
Well, if they're to stay together. But what I would say is that the domestic jurisprudence, such as AB Jamaica, VW Uganda, LM Democratic Republic of the Congo, various authorities I've referred to in my written case make clear, as does EB Kosovo, that that isn't the only option open to the British citizen and their partner. It is, moreover, as Lord Bingham said, a question of the proportionality of the separation of the couple. So we would say it is, at the very least, obtuse for the rules to be framed in one manner alone, that the caseworker will only look at whether there are insurmountable obstacles to the British partner going abroad to continue their family life, and will not look at, for example, the proportionality in the couple separating and the couple, perhaps the partner reapplying for entry clearance. This ties in to a certain extent with my Chikwamba argument as well. So it's an important observation that the rules as they are currently drafted only consider one option open to the couple. But that's important because, and I won't repeat my submission to my written case, British citizens, of course, are not subject to control. They have choices as to where they want to live or choose to live. They can choose to stay here and sponsor the partner. So it doesn't take into account, for example, that if the British citizen is to go abroad and relocate, how could they ever sponsor the partner to come back here again? How could they ever return to their homeland? It's just not possible because the rules are fixated upon departure after departure. There's no question of the partner bringing themselves into the rule at all, or whether it's proportionate to ask them to go back and apply. Is that truly a proportionate outcome of immigration control versus the personal interests of the applicant and the disruption to their lives? There's no question of that at all in the rules or in the guidance, which I'm going to turn to now. I also have a marker to ask the tribunal to note in that context as well, LMDRC, and that is at volume 4, tab 37, and the starting page of the judgment is MS 1300. Forgive me, the paragraph numbers I don't have in my speaking note, but they are already reflected in the statement of cases, the very same paragraphs I rely upon again. But it's in this context that I would ask the panel to look at it. Now, of course, in the Court of Appeal in
What's
LM...
the point you want us to take from LMDRC?
The point I ask you to take, my lady, is that the insurmountable obstacles test, which I say it now is because it's not a consideration but a test, is insuperable. It is an insuperable obstacle. I say it is highly analogous, if not worse, than the situation that the Secretary of State was pursuing in LM, Democratic Republic of the Congo. And that is made clear by EX2 of the immigration rules. Now, again, before I make this submission, I preempt it by saying this descriptor of what an insurmountable obstacle is was not in force at the time, but in terms of clarifying what the Secretary of State's true intention is of this phrase and the use of it, it is helpful. So that is to be found at volume 1, tab 5, MS 76. And if my lords and ladies don't want to turn it up, I can read it in slow speech. I'll pause.
Well, 76, and it explains what insurmountable obstacles means.
I have
it's
the
in
right
your case. I mean, you set it out in your case.
It is set out, but I say that if it means something that could not be overcome, that is the precise same thing as an insuperable obstacle, which the Court of Appeal already denigrated in LM. So it's a return to insuperability.
Well, it's not limited, is it, to whether you can overcome it. EX2, which could not be overcome or would entail very serious hardship. So it's not limited to insuperability in the strict sense.
It's not as limited as perhaps in it being the sole parameter, but it's an idea of what a caseworker reading this would think. They, taking the plain English understanding of this, would not fail to note it's something that can't be overcome and would have to look for something pretty outrageous or serious to stop the British citizen upping sticks and moving abroad.
The conventional connotation of insuperable means surely something that cannot be overcome, whereas insurmountable difficulties are defined here as my Lord has said, difficulties which are of an exceptional nature and may be overcome. At least they may constitute a reason for not enforcing the decision to send the person away.
My Lord, I would say that it is somewhat worse than that, at least at the time of this decision, because of the guidance, and I'll turn to that now to illustrate the point. The paragraph in question is 3.2.7c, and that is contained in both the May 2013 guidance, but also in the August 2015 guidance, so it's still in force. And if I can direct your attention then to the later guidance, because it's far more easy to read, as it were, in terms of the layout. That is at volume 1, tab 10, and the MS number is 349. And I would greatly pray and aid this piece of guidance in, notwithstanding EX2, which wasn't enforced at the time, calibrating what has been enforced throughout and what a caseworker will look at. They will, of course, read the rule, or they may be familiar with it after a few weeks of operating it, but the guidance is what guides them, and it's what they will always go to. So
You said tab 110 was the most recent guidance, but actually it's the 2013 guidance.
Oh, forgive me, not tab, I do apologise, not tab 110.
Tab 11 is the
It's
15 guidance.
Yes, I mean, you're referring us to page 349, which is tab 11.
Then I do apologise. I was typing the MS numbers late into the night. I'm terribly sorry.
So what are we looking at? 349?
We're looking at MS 349, my lord, and paragraph 3.2.7c, which contains in it...
Wait a minute.
7c is the overall...
A number in the earlier guidance.
And on MS... Forgive me one moment. Panel can pause for just one moment. I'll try and find the relevant paragraph.
Same material.
But this is 6.2.3.3.
It's got a different number, hasn't it?
It has now, yes, but it's the same wording, as it were, lifted to another paragraph number. I'm referring to this because it's more easy to read, as it were. The paragraph in question starts just above the halfway. It is. I've checked. The paragraph in question is that which appears just above halfway down the page, the assessment of whether
insurmountable obstacles.
Yes. So, as it says here, my lady, the assessment is, if there's a different and more stringent assessment, whether it would be reasonable to expect. So clearly we have a departure here from EB Kosovo and the reasonableness of the expectation of the couple separating, as it were, but on this occasion it's actually relocating. And we also have, in the same paragraph, a fairly alarming example there, that a British citizen partner who has lived in the UK all their life, has friends and family here, works here, speaks only English, may not wish to uproot and relocate halfway across the world, and it may be very difficult for them to do so, but a significant degree of hardship or convenience does not amount to an insurmountable obstacle. So here we have a description that an insurmountable obstacle is in fact, I would say, insuperable or something which can be equiparated with that, because if a British citizen has to relocate halfway around the world, a country that's not their own, can't speak the language, has to leave everything behind, that's also not insurmountable, which is not what Strasbourg says at all.
Is that, I mean, are you saying this is inconsistent with jeunesse?
I say it's also inconsistent with jeunesse for reasons I'll turn to.
Well, jeunesse applies a very high threshold for insurmountable obstacles, but then finds other reasons under Article 8.
My Lord, jeunesse is something of an anomaly, I would say, because there are no insurmountable obstacles thought to exist in jeunesse, but somehow the Strasbourg court, in giving minimum protection, says there are exceptional circumstances lurking somewhere in these facts, but none are particularly designated as exceptional. And according to the guidance's definition of what is exceptional, those are different.
Well, that's a different point. But as to the question of what is insurmountable, they seem to have thought it wasn't insurmountable for this Dutch family who'd been living in Holland for years to uproot itself and go off to Suriname.
Yes, and I think the reason for that, in particular, is because they were exercised of the immigration history and wrong, as if I can put it that way, politely, of Miss Jeunesse, because I'm going to turn to this in more detail later, but she was in a relationship before she went to the Netherlands with her partner, and she had been since 1987. The partner then went to the Netherlands in 91, and she decided to come and join him afterwards, but didn't apply through the proper channels. So she had the ample opportunity to apply and follow the correct procedure, but she didn't do it to procure her family reunion.
So that doesn't go to the question of whether it was insurmountable.
Well, it goes to the...
who had been living and was naturalised Dutch citizen, I mean, living there for years, and was working there, to uproot himself and go off to Suriname with his children.
Well, my Lord, in terms of that being an insurmountable obstacle, that is an illustration of the Strasbourg Court's idea on this particular occasion, but it isn't a recurring theme in the Strasbourg jurisprudence. It's not a clear and constant indicator that the partner would always relocate, regardless of how long they have been in the Netherlands. But in particular, it's because of their shared original citizenship that the court were more exercised with the fact that the applicant, Jeunesse, perhaps couldn't preannate that descriptor. So, for example, with Miss Agyarko, the ethnicity is entirely different. So it isn't on all fours with Jeunesse in this particular appeal. And I would say that it is something which clearly influenced the court in Strasbourg, that they are of a shared background. They were originally there together when they were both Surinamese, and they have come here together, formulated a life. But she did so when she could have easily applied for the residence permit after her partner became a Dutch national, which she didn't do. So it was a fair criticism to make of her. And I say that's a very distinguishing fact, which distinguishes Jeunesse from the instant appeals, for example. But I would
say that Jeunesse, where indeed the Grand Chamber both laid down principles and held that she should have been allowed to stay, is a much stronger case than either of yours, for the reasons that you've just been stating.
My lady, I say it's not much stronger. I say it's stronger, of course, but there are factors which haven't been considered in the cases of my particular appellants.
Yes, your main point is that insurmountable obstacles is not the test, under Article 8 at least.
It is, my lady, and I say that is described in this paragraph in the guidance as a British citizen needing to move halfway around the world, not speaking the language, isn't an insurmountable obstacle. This precise language here and the example given...
This precise language wasn't even written at the time of the decision under challenge.
It was, my lord.
The relevant guidance...
Page 291.
It's 291.
That text.
Yeah.
It is not the same language. I mean, the factors at the bottom of page 291 may be very similar to the factors on page 349, but the passage that you're putting such stress on is not in the earlier guidance.
what is in both sets is the paragraph which begins lack of knowledge of a language. But I mean, to the extent that it matters, it is actually tab 10, which was in existence for the caseworkers at the time of the decisions that we're concerned with, was it?
Yes.
Well, Lord, staying with that then, I appear to be conflicted on that point, but it does give colour to the way in which insurmountable obstacles are assessed.
Well, you've got the same point
But
about the severity of insurmountable obstacles. It's put in different language.
it is.
In these two things. At first, I was thinking that you were saying they were the same. They're not.
They're not quite the same. I do apologise. What I was saying, though, is that the examples given, for example, on 291 of A through to B and C, are examples, we would say, of a parody of an insurmountable obstacles consideration. The point being, this is the only way in which you can succeed under the rules. That is the long and short of it. If you can't show there is the inability to enter, in terms of immigration law, the third country which you're proposing to remove the partner and that the British citizen has no choice but must go to, and that there are cultural religious barriers. These are, and for example, the impact on mental and physical disability, these are very extreme examples of what an insurmountable obstacle could be, but they are not the only possible examples. But giving these examples sets the bar so high that it is an insuperable obstacle, we say. It's not just an insurmountable obstacle, it's higher than that. But not just that, it's the only way in which you can succeed if you are an overstayer or if you don't have status. So it is
I had
almost
thought
impossible.
that the latter was the point that you were making, that the rules and the guidance were, I thought you were saying, were making into a requirement something which in Strasbourg jurisprudence was treated as a relevant factor.
Yes, that is my underlying submission behind all of this exploration of the guidance, is that it's merely a factor or consideration in Strasbourg jurisprudence, for example, in Rodriguez at paragraph 39, which the Secretary of State has heavily relied upon. It's simply listed as a factor or a consideration, but it is not the only factor or consideration. But elevating that to a test, and the only means in which one can be given leave or deemed to be proportionate under the rules, is a warped transposition of Rodriguez. Rodriguez has many factors mentioned at paragraph 39, but why only one of those should appear in EX1B has not been explained at all in the respondent's statement of case or supplementary statement of case. Simply something that is not merely highly unattractive, but is unlawful. If Rodriguez is an example of the recurring considerations of the Strasbourg court, and if those are the minimum protection that is to be given to the fundamental right, having a test that takes one of those out of the basket and says, meet this, that clearly violates the minimum protection warranted by Strasbourg. If this matter were before the court, it would be a violation because it goes below the minimum required of member states. And I would ask the panel to reflect that the Strasbourg jurisprudence can't be as case-specific as that of our domestic curial hierarchy because it can only take into account the generality of cases that come to its door. And also, it can't take into account the particular way in which, for example, rules are laid, etc., or rules are passed or brought into force. It can only take into account the general facts that are before it. So even on that generalized approach, Rodriguez suggests you have to look at everything. These are examples I would invite you to find of what you should look at. And taking one example, raising it to a bar of the minimum that must be met violates the minimum protection required by Strasbourg.
I wonder about your point about it being unlawful. As I understand the Secretary of State's position now, whatever it may have been then, she accepts that the rules are not the final word on Article 8 and that there has to be, in certain cases, a subsequent Article 8 assessment outside the rules. Now, if that is the case, and the rules are no longer being touted as a codification of Article 8, is the two-stage process on your submission unlawful?
The two-stage process is not directly unlawful if the second stage is based upon the judgment in Razgar and Wang and takes a structured proportionality assessment.
The real debate isn't whether the rules themselves are unlawful. The real debate is what is the content of the second stage test.
Well, if I can... Yes and no, my lord. If I can put it this way, if the Secretary of State is fairly proud of herself for passing and laying a rule which violates Strasbourg's minimum protection afforded to migrants within member states, that's something she should jolly well rectify outside the rules and do so explicitly. Because if you are going to raise one consideration out of all those in the basket to a test, you should tell caseworkers, who are of course not expert lawyers, that this, in fact, is not what Strasbourg requires. Now could you please forget everything you've done and just consider everything, and not that this should be something exceptional which has already failed. That's the point. The exceptional circumstances guidance, which I'm going to turn to in a minute, says that if the rules are not met, you must refuse the application. It's in my written case, but it's RLTRP 1.1d. You must refuse it. But the point is, if you must refuse it, and there has to be something exceptional or genuinely exceptional outside of that, it's hard to imagine anything that could possibly meet such a high threshold when a British citizen, for example, relocating isn't an insurmountable obstacle. It has to be something even far worse than that. It's hard to think of anything that could be more extreme or severe than asking a national to move abroad with no question of looking at re-entry or separation at all. So I will turn to the exceptional circumstances guidance as calibrating or giving examples of what caseworkers are told is exceptional, but I say that the descriptors used in that guidance are objectionable. That takes me, in fact, to another passing point, which I'm not going to spend much time on, which is the Senade point, or the Zambrano point. In my written case, I do pray reliance on Senade, and in particular...
Did you argue this in the Court of Appeal, as a matter of interest?
It was in my written grounds. It, in the course of the hearing, was not raised, but it was a point on appeal, yes. But it's something which wasn't addressed by the Secretary of State at all in her written argument. And it seems it's only been addressed, I would say now for the first time, in the supplementary statement we received yesterday. So, in terms of Senade, that is to be found at volume 5, tab 56, and the MS number for the start of the judgment is 1273. I would rely in particular on paragraphs 83 through to 95. Out of those paragraphs, I would particularly rely on 83, 94 and 95.
I'm sorry, could you give me that?
The MS number, my lady?
Could you give me the page again?
The page is MS 1273.
1273.
Try 1723, Mr.
Yes.
Sailing. Just a simple transposition. 1723.
I'm sorry, my lord.
Thank you.
Mr. Saini, you're quite soft-spoken. Lord Hughes has already said he's struggled to hear everything. I'm closer to you, but I haven't heard every word. Can you try and project your voice?
My lord, I'm very sorry.
Thank you.
We realise these are challenging circumstances for any advocate, but we do need to hear you.
Oh, naturally, my lady, I do apologise.
So 1723, Senade.
Yes, and paragraphs 83, 94 and 95 in particular.
have you got a page reference for that or not?
1747 is 94 and 95.
1745 onwards.
I'm grateful, my lords. What is said therein is that it cannot be reasonable, following consideration explicitly by the Secretary of State answering a question posed by the President of the Upper Tribunal in terms of, and I understand completely this is a deportation matter, but it cannot be reasonable for a partner or a child to relocate without or out with the European Union. So the point that raises originates from Zambrano, of course.
So
And
I'm still trying to catch up with it.
Forgive me, my lord.
What is the point we get from paragraph 94?
The point we get, I'll turn it up. Forgive me one moment, my lord. The point we get from 94, my lord, is that there was explicit consideration of the issue by the Secretary of State as to the implications of the Zambrano judgment. And on that occasion, the executive in question, Mr. Devereux, did answer that in the positive that when assessing the compatibility of removal, I'm reading for him from the indented paragraph, with the European Convention, it will of course not logically be possible to argue that any interference could be avoided by the family unit moving to a country which is outside of the European Union. So that was the Secretary of State's...
This is removal rather than refusal to admit, is it?
Well, my lord, I say...
You say the same applies, I'm sure.
Same applies.
This is removal, is it?
It is removal, as opposed to refusal to admit from an third country.
Precisely.
Yes.
Is there a difference?
Well, I would say that in terms of... It's not my case, but in terms of, for example, the child...
Does jeunesse not make such a difference?
My lord, I would say jeunesse didn't cover this fact, which I'm going to come to in a moment, explicitly because the European Court were not able to be apprised of it, if I can put it that way. I'll find the paragraph reference momentarily. But the point is, if say, for example, there's a child applicant from out of country and the British parent in the United Kingdom would be compelled to leave the United Kingdom in order to family life to continue, the Zambrano principle would apply because it would be compelling the parent to leave the European Union to continue family life with the child. But that's not, as it were, the facts of my case. My facts are strictly in country anyhow. But my understanding is it would be a relevant factor.
It would come to the same point, wouldn't it?
The question comes down to...
Take from 94 and 95, just to make sure I understand what you're saying.
The submission I ask you to take away, my lord, is that the Secretary of State previously accepted that it's not logically possible when assessing the compatibility of removal explicitly with the Convention and interference with Article 8 rights to say you can avoid incompatibility by the family moving to a country outside of the European Union. That's precisely what's proposed here in terms of EX1B.
What those paragraphs are saying? I have my doubts. I read them as saying that you don't get into interference at all because the family can move. And in 95, the upper tribunal was saying, no, you do. You have to justify. You have to justify the separation that you're seeking. I don't think it's saying it's going as far as you're suggesting.
Well, my lord, the 95 does make clear that, in the words of the presidential panel, it is not possible to require them to relocate outside of the EU or to submit that it would be reasonable for them to do so. Those are the findings of the panel based upon not only what is said by Mr. Devereux, but their agreement with what he says and his understanding of the Zambrano ratio. So in other words, the president of the Specialist Tribunal agreed that this is a correct extrapolation of the ratio. In this particular case, it was a deportation, but that brings me to another point, which is the public interest in deportation appeals is slightly heavier than when one is dealing with an overstayer. And as my Lord Sir Stephen Steadley said in granting permission to one of these appellants, they're not criminals. They're merely here as overstayers. It all comes down to fairness and reasonableness. But if you're going to even look at that parameter of reasonableness, which the Secretary of State has not done in my submission, even then, you should not consider the British partner relocating outside the EU or compelling them or requiring them to do so, because that would violate the Zambrano ratio. It's a fairly, it's not a convention point, but it's a citizenship point, as it were, in terms of Article 20 of the Treaty for the Functioning of the European Union. Which takes me to the reference, which I won't ask you to turn up, but where the ratio originates from, which is at 41 to 43 of Zambrano. And Zambrano, I think I have the MS number, which means I need to now trace the volume number as well. Just one moment, I apologise. I think it might be in volume 6, my lords and lady, at 2279, which would be volume 6, tab 70. There,
Yes, it is.
I believe, yes, on the penultimate page of the judgment should be the relevant paragraphs.
Penultimate page of the judgment.
Yeah.
So if I did promise I would look at jeunesse in response to my Lord Hughes' query of what happened in jeunesse on this topic. I will return to it if I may. It does feature further on in my exploration of jeunesse.
You take things in your own order.
I'm grateful, my lady.
You're labouring under enough difficulty. We're beginning to realise just how useful juniors are, Mr. Saini. You do not have the benefit of a junior.
I don't, my lady.
We understand that makes it much more difficult for you to find the right references and give us the right page numbers at the time when we're wanting them. So
I'm grateful, my lady.
you have our sympathy.
I'm grateful for that.
But do continue in
Yes,
the way that you want to continue.
I will, my lady. So I would say that the effect of the guidance alongside EX1B means that you are going to have to look at, as a caseworker would, the British citizen relocating halfway across the world. That's not what the Strasbourg court meant in Abdelaziz in 1985. And the whole basis upon which the Secretary of State's case rests in terms of upholding the positive and negative obligation, of course, originates from that judgment in paragraph 68. In Abdelaziz, it was simply said that there wasn't an obligation, general obligation, to give preference to the right of the couple where they want to live. But that doesn't mean you should automatically consider requiring the citizen to depart halfway around the world to somewhere where they don't know and they don't speak the language. That is asking someone to change the very nature of their everyday existence, their way of life. It can't be that that doesn't feature as interference in someone's right to respect for their family life, let alone the private life of the citizen. Because, of course, the convention would equally apply to the partner, but the guidance doesn't ask you to look at the partner, just at the applicant. That's a very important omission in terms of the rules and the guidance and saying that everything is covered under the rules or outside them. So, in terms of the rules not being met, they are very high. They ask that someone relocate, but you don't take into account the family life, as it were, or the private life of that British citizen, because they can always go abroad and live somewhere else to keep their family life intact. And on the other hand, when you look at exceptional circumstances, that's not exceptional because it didn't meet our rules in the first place. So what is exceptional? It has to be something fairly extreme, I would say.
Can I ask you, just thinking about how you relate this to your application for judicial review of a decision, is your argument that the decision is vitiated because the Secretary of State has misunderstood the significance of insurmountable obstacles in the Strasbourg case law, or are you saying the decision is simply in breach of Section 6 of the Human Rights Act? Or both?
I say it's more explicitly the former rather than the latter, although the latter, of course, would apply if the former is met. I wouldn't say it's a question of misunderstanding, because this is a considered piece of practice and rule-making, as it were. I would say it is something which is purposefully done, that the insurmountable obstacle test is a test, not a consideration. If that had not been meant, the wording would have been different in EX1B. I can't find an excuse for it in the respondent's statement of case, but I'm sure there will be something forthcoming from them. In terms then of...
So it's an illegitimate departure from Strasbourg jurisprudence.
Quite clearly.
And thus a breach of Section 6.
Absolutely, my lord. My lord, the respondent's case is pinned on all fours to the fact that the rules ape the Strasbourg jurisprudence. I've clearly shown they do not. And that is clear even if I were not here on the terms of contrasting paragraph 39 of Rodriguez to EX1B. There is no marriage at all there.
But isn't your other point that irrespective of what the Strasbourg jurisprudence says, there are two House of Lords decisions which are pretty clear?
There are, my lady. I've already said that in my written case, so I'm not, as I said at the outset, I'm not going to repeat what I've already said.
Rather more serious departing from House of Lords or Supreme Court decisions than departing from Strasbourg decisions.
It is,
We're
it
allowed
is, my
to do
lady.
that, as is the Secretary of State.
My lady, yes, that is something I am again coming to, which I'm conscious that I may not come to, but I will try to. In terms of Section 2, you must only take account of the Strasbourg jurisprudence. That's made clear time and again. I think it was in Quiller at 43 as well, for example. That was said by my Lord Wilson. But the point is, as long as you take account of it, that is all that one must do. For example, on that topic, and on that note, the criticism of Lord Bingham's judgment by Mr. Justice Sales, as he then was in Nagre, is, I would say, unfounded. Because if one looks at E.B. Kosovo, Huang, Razgar, the Strasbourg jurisprudence, which is where Jeunesse and Rodriguez originate from, was before the House at the time. It's all matters that were taken into account already, and this is all something that's already been rehearsed. It's simply originating and being presented in a somewhat more presentable fashion now in terms of a codification to the rules. But again, it doesn't have democratic approval anyhow, which is its key, as it were, distinguishing factor from what previously went before. It's now codified, so would you please accept these arguments now? Why would they? Why would the court accept them when there hasn't been any departure and there has certainly now been a fettering of proportionality outside the rules under the residual discretion, which was previously open-ended and where caseworkers could consider all factors equally?
I'm just trying to keep track of this. So there's an error of law, there's a failure to follow Strasbourg jurisprudence, or take account of Strasbourg jurisprudence correct on a proper understanding of it. Secondly, there's an error of law because of the failure to follow binding domestic precedent.
Precisely.
And thirdly, there's an illegitimate fettering of discretion as a matter of domestic administrative law.
Precisely, my lord. My lord has said it much better than I've been able to in an hour and a half. Before I leave the topic of the British citizen, I would only ask the court to note also that in terms of requiring the relocation of a British citizen, this, as I say, is not something the Secretary of State can consider because citizens are not subject to control. They have an inalienable right of abode. But also, this isn't one of the enumerated considerations under Article 8.2, which are mundane things such as the economic well-being, etc. None of that means that a citizen is required to relocate. Those can be preserved by separation of the couple equally, And again, it begs the question, why not consider the separation of the couple? Why only consider the relocation of the citizen who is not subject to your control and who you have no say over whatsoever, particularly when you do not know what choice the citizen will follow? Will the citizen go or not? It may be they'll say, I've had enough of Britain. I think I will now move to the country of my spouse's choice instead. But it may equally be that they say, well, will in fact miss my parents and my children here and my job and all my friends I've had all my life. On the other hand, I can't actually speak the language there. Why should I go? It's an option open to them. And I may be parodying what might actually take place, but I do so because of the extremity of the circumstances which are faced by these British citizens when they make applications on behalf of their partner. And one would have thought, if someone goes to the extent of paying a great deal of money, which they are now fairly expensive, these applications, to ask for their spouse to stay, they are implicitly saying, well, I don't actually want to leave. Could you please let my spouse stay here instead?
What is the test? I mean, if I, as a British citizen, choose to marry someone who doesn't have a right to come here, what is the test for deciding whether that person should be allowed to come here by the Secretary of State?
The test should be just a conventional proportionality assessment.
I know, but I mean, that's bully.
If you want specifics, my lord, then I would say the test should be, I would say the ideal scenario would be the Secretary of State poses a question in her application form for these applicants as to whether the citizen wishes to stay here or not. If not, what are the reasons the citizen wants to stay, for example?
I mean, it's up to the citizen. If I choose to marry someone who's not entitled to come here, I've obviously made a choice which has risks.
I see.
And it's not ready for the Secretary of State to sort out my life for me. I don't think. But there's got to be some sort of coherent, consistent test for deciding whether I'm entitled to expect that person to be given exceptional status or not. And what is the test?
Well, I know the test. I do apologise. I can't pretend to know the answer.
Proportionality.
Well, I mean,
I say it's that, but
it means nothing.
But that's what he
Conventional
says.
proportionality means nothing.
May even be the law.
Well,
Weren't you
surely
contending
you say
for...
you look at all of the circumstances of the case and then apply the well-established proportionality
Throw it
pages.
all up and say, well, is it a good thing or not? I mean, it's too woolly.
I think, well, my lord, if that's the only umbrage with the test, then I wouldn't be here. But it's more the fact that, is it fair or not, is the question that should be asked by caseworkers, looking at everything possible.
One view is it's fair if I've chosen to marry someone that I should be allowed to live with them, even if that involves an exception to the rules. Another view is that I've chosen to marry someone who's not entitled to come here, I must live with that consequence. I mean, those are two perfectly reasonable points of view. What's the test?
Well, the test should be then, should they be permitted to stay in the country according to the norms of what might be required of if they were entering from out of the country? For example, do they have a maintenance and accommodation? Do they have a job of their own?
Yeah.
Does the partner have a job that can support them equally?
All those are
Are there children?
Yeah.
But I can't distill it to a particular question, because that's precisely what the Secretary of State has done, which is what I say is wrong.
That's right.
I thought, reading your case, I thought you were commending the test. Is it reasonable to expect them to leave?
That is the question I commend, but that would, of course, be synonymous with the fair balance and the final stage, as it were, of the Rasgar questions. It's not the only question, is what I'm saying, but it is the most pertinent question, certainly. Fair balance and reasonableness. What is fair? And that certainly isn't followed. I won't repeat my submissions, but when there is a test, how can that be followed? You're not allowing caseworkers to even follow it. Even if a caseworker thought, well, if I was to move halfway around the world, I don't think I would like it. That's quite unfair. But I have to refuse it because it's not insurmountable. So that, for example, isn't something which is fair or proportionate. But I can't give a precise definition, as it were. I do apologise. But reasonableness is, I would say, and fairness is the catchword or the the safety net, as it were, in preserving the minimum protection for the fundamental right.
Can I ask you for a moment, Mr. Saini, just going back to Zambrano? That was a very strong case in that the EU citizens, the children, were totally dependent on the parents who were going to have to leave the EU. I wonder, I don't think we have in front of us the Derecci case, but isn't that more in point? Being, if I recollect it, being a case where you had a couple, one of whom was an EU citizen, the other one not, but the EU citizen was not dependent on the partner, and wasn't compelled by reason of dependency to leave the EU if the partner were removed from the member state.
My lord, Derecci is relevant. I'm surprised the respondents haven't relied on Derecci, as it probably is the strongest authority in their favour.
Well,
it speaks of compulsion.
In that case, at some point, perhaps we ought to look at it.
Perhaps, my lord. What I would say in brief terms is that it speaks of whether someone is compelled to leave or required to leave. The terms are used interchangeably, though, compulsion and requirements and oblige. I haven't put it before, my lords and lady, but the recent case of CS, which the upper tribunal referred to the European Court, and the opinion there of the judge in question was, is the citizen obliged to leave the European Union? Of course, that's just the Advocate General's opinion at the moment. We haven't reached the chamber decision yet, but the opinion is it's a question of obligation as opposed to compulsion. So it's very much undefined or at present, and it's a very imprecise ratio. I can't really be more useful than to say that. It's fairly fluid at present. My lords and lady, turning back to the guidance momentarily. Forgive me, I'll move on, I think. Briefly, before I move on, I've already prayed and aid AB Jamaican VW Uganda from the Court of Appeal. I would say that the Secretary of State's supplementary case is poignant at paragraph 34, for example, because it says that AB Jamaica was concerned with the cavalier treatment of a British citizen's rights. And those are, it was admitted, as much engaged as those of the partner. Well then, if that is the case, why doesn't the guidance say that? The Secretary of State accepts it, but her guidance doesn't say it. There's a discrepancy.
Did you refer to the supplementary case of this?
Yes, the supplementary statement of case.
Oh.
Supplementary statement of case which came in yesterday.
Yes, paragraph 34.
34.
Yes,
It's
34.
headed, the external page says respondents' additional documents, but
yes.
actually it's another case.
I see.
Yes.
Well, I put my hands up. I'm afraid I haven't read it.
I haven't
But I will read
spotted
it
it
over the
either,
short adjournment.
I'm in the same boat.
Yes.
34.
Yes, my lord. My lords, just briefly before I leave this topic as swiftly as I can, I'm conscious of the shortness of time. I also prayed and aid MF Nigeria from the Court of Appeal because it approved explicitly paragraphs 53 to 59 of the upper tribunal's decision in Izuazu, which represented the first comprehensive exploration of the rules. And of course, those are the rules as they were when the decisions were made. There was no exploration or excavation of anything modern, which I may have looked at today. I say that remains an authoritative stance, and I would also ask the panel to note that the judgment of Huang was also approved at paragraph 20, as were EB Kosovo, which I again say is a difficulty that the Secretary of State has not overcome yet in my humble submission. I would ask and commend the panel to look at Izuazu at 53 to 59. Izuazu is located at volume 5, tab 57, and the MS number is I have put it as 1756. I'm just going to double check it's correct. It's 1770 is 53 to 59 of Isuwazu. There is a shortness of time, so I won't go through each paragraph, but it's fairly important that I touch upon two of those paragraphs. And they are, just in passing, 54, for example, and 55 mention Rodriguez. There's an explicit consideration by the Specialist Tribunal of Rodriguez, followed by Nunes in Norway, followed by Antwi in Norway, all authorities that the Secretary of State praise in aid today before this court, which have already been dealt with and considered to be of no assistance to her cause. I would commend the panel to uphold these paragraphs also, and the remainder of the judgment, in fact. It hasn't been challenged. It wasn't challenged even at the time on appeal to the Court of Appeal by the Secretary of State, so she clearly accepts what is said here. But what is said at 53 to 59 is discrepant with her current stance, and in the face of that presidential decision of the Specialist Tribunal, it's hard to see or argue with the logic and the wisdom that is expounded in those paragraphs. For example, at 56, the precarious issue is taken into account. And it said that it's one of several factors to be taken into account by the Strasbourg court. But then it repeats the submission which I have made, which is that the new rules, HC 194, impose a test that has to be met. And I underline those words, that it has to be met, because it's a minimum requirement. Looking at, again, for example, looking at that, forgive me one moment, in analogy with jeunesse, if insurmountable obstacles have to be met, then why did jeunesse succeed? There's a clear discrepancy between the rules and Strasbourg. The clear and constant jurisprudence, if anything, says Strasbourg is moving away from a formally aggressive stance, one might say, of the minimum protection required, and is opining, as it were, that insurmountable obstacles are not the be-all and end-all, or they do not need to be shown if there's a precarious migrant. Admittedly, exceptional circumstances were found, but looking at Rodriguez, which is where all of this comes from, the judgment is quite stark in that at 39 of Rodriguez, it says you've got to have insurmountable obstacles, or you've got to have exceptional circumstances if you're here precariously. But then from 40 to 44 afterwards in Rodriguez, there's no mention of any being found, and yet removal is thought to be, and is said to be, disproportionate. So, if anything, the key authority, which is the basis for the entire rule change, makes clear that the two criterion that the Secretary of State use, insurmountable obstacles and exceptional circumstances, don't have to be met for removal to be disproportionate. I've made a great many submissions enforcing the point that the Strasbourg court is a court of minimum protection. That is echoed by the upper tribunal at paragraph 60 also of Isuwazu. It's not a paragraph explicitly referred to in MF Nigeria, but it happens to be parallel and is of curiosity at least. My submission would be that in terms of whether there can be any move away from the House of Lords authorities, that would require the margin of appreciation of the Secretary of State to be given deference, and also that deference to be followed suit by the court. Now, I've already made extensive submissions on why that should not be, because of the manner in which the rules have been laid. They haven't been assessed by Parliament, as it were, for the full ambit. But that is supported also by an authority which recurs in the bundles of Handyside versus the United Kingdom. Forgive me, I do not have, and I can provide them after the lunch hour, the paragraph numbers for Handyside. But I believe I mentioned them already in my written case. But there's an important point there that the democratic, the margin of appreciation does extend to both of the national authorities, both the executive and the judicial arms of government. So, as it were, even if there is a legitimate margin which has been exercised by the executive, that of course has to be calibrated by the judicial arm in our separation of powers as part of the national authorities and the highest court in this country in protecting the minimum necessary for a right to respect for family life.
Handicide is Authorities Volume 5, tab 59, starts at 2013. Rather than come back to it, if there's anything in particular in Handicide you want to refer us to, it might be convenient for you to do so now.
I will just check, my lord.
Page 2025, Article 10 leaves to the contracting states a margin of appreciation. And the margin is given both to the domestic legislator and to the bodies judicial, amongst others, that are called upon to interpret and apply the laws. It's the final sentence in paragraph 48.
My lord, yes, that in fact I believe that 48 is one of the paragraphs I was going to direct the panel's attention to, but also elsewhere. I apologise. One moment, if I just have a look through.
It also says much the same thing in paragraph 49 and 54. Essentially, your point is that the margin of appreciation is to be given effect to not only by the legislators but also by the judicial authorities. Is that the point you're making?
That is the short point I'm making, my lord, yes. It is not something that's confined simply to the executive, as the statement of intent would have the public, or the Parliament indeed, understand. I also would pray and aid the authority of in re G, which is in the appellant's additional documents. So it is an authority nestled in one of the blue bundles, and that is at
the Northern Ireland adoption case.
It is.
Yeah.
It is. In particular, I would rely upon paragraphs 30 to 38, which are, I think, MS 3313, but I will double check.
Which paragraph?
Thank you, Mr. Giovanetti. 3325.
4 and 3325.
Sorry?
3324 and 3325, my name.
It's in the additional
38, so it's 3325, 3326. Yes.
In particular, the submissions I have made already regarding the Strasbourg court are reflected at 32, but importantly, in relying on 30, which simply cites the Ulla principle from Lord Bingham's judgment in that matter, it's important to note, I would say that it's a question for the national authorities collectively, and that an international court such as Strasbourg can only secure the minimum necessary. And the question of the margin of appreciation is one for the state collectively, as it said at 32, the legislature, the executive, or the judiciary. It's a matter for the entirety of the state's organs. So I also would point particular attention to 35, because it gives reasons for also following and also not following Strasbourg, and the extent to which perhaps the taking account can or should be done. I understand that's a question put by Lord Kerr in the previous appeals. So it's allowing, as it says there, the last sentence of 35, for the possibility of a dialogue between Strasbourg and the courts of the United Kingdom over the meaning of an article. But it's a rare occurrence. And that, I say, is because, of course, there is a minimum protection necessary, which Strasbourg will always make clear, and in this instance anyhow has been violated. In terms of the guidance, there is a final passage I would ask the court to note, and I will find it first before I give you the MS number. I apologise. One moment.
Which is the case that you want to refer us to?
It's in the appellant's additional documents, the third tab, although it doesn't seem to be tabbed, but it's given us page numbers 19 to 92, the relevant guidance in force at the time. I'm cautious that I should refer perhaps now to that, so that no confusion arises. And it's in particular paragraph 3.2.7d, and that appears at page forgive me, one moment. 3.2.8, not 0.7d, forgive me. That's at MS 3276, and it's at page 56 of the appellant's additional documents. And it's simply for the last paragraph on page 56. That's the pagination in the middle of the bottom of the page, which occurs halfway through the last paragraph. A case is not exceptional just because the criteria set out in EX1 have been missed by a small margin. Exceptional means circumstances in which refusal would result in unjustifiably harsh consequences for the family. So I say that is a parameter that doesn't accord with the Strasbourg approach of fair balance, for example. Equally, the final sentence at the top of the next page, that it is likely to be the case only very rarely that such matters would be met, also is in conflict, as it were, with Wang and other domestic jurisprudence too.
Do I take it that when you referred us earlier to tabs 10 and 11, being 11 being the current rule, the current guidance, and 10 being earlier guidance, it's actually this one we now have in front of us that was in force at the time of the decision?
It was, my lord. That's why I put it in the additional documents.
So we should ignore tab 10 then?
My lord, yes. This is
May 2013.
This is absolutely what was
This
there
is the one we should be looking at.
Yes.
Thank you.
Indeed, my lord.
Is there anything wrong with the unjustifiably harsh consequences approach?
My lord, I say yes. That test, as it were, along with the terminology that it is to be viewed against the backdrop that one has failed to already meet the rules, alongside the fact that it is said it's incredibly rare or very rare, is a particularly high threshold for proportionality. The Secretary of State's case is heavily reliant upon the fact that, and this is to a large extent covered in her supplementary statement of case, she spends a great deal of that supplementary statement saying the residual discretion is what counts, because there is a proportionality assessment outside the rules by the Secretary of State. But on the other hand, if this is what proportionality looks like, it's not true. It's simply a false submission.
Sorry, I don't know, where does the unjustifiably harsh test come from?
That comes from the bottom of page 56.
I know it's in the guidance.
Oh, where it comes from? I'm not
Does
sure.
it come from any authority?
I have not seen it, my lord, in the Strasbourg authorities referred to.
Or in the English authority?
No, my lord, no. It's a new twist in the tail, as it were.
You say it's too stringent.
It is too stringent against the parameters of reasonableness and fairness. Very unjustifiably harsh, calls into question again the caseworker's view, or what they are informed of what is justifiable, which is why I went through the rules in great detail this morning, because the Secretary of State says her view of the public interest is what is justifiable, because it's democratic. It's the country's view of what's justifiable. So if that is, as I've already I've shown that's hollow, if that is what caseworkers are told is justifiable, it has to be something that is over and above that justifiability given weight or colour by the rules and the statement of intent put before Parliament. So I have prayed and aid a case from the Scottish Inner Court of Session of Mirza, which discusses this. I think it's at 21 to 22. In fact, let me give the MS number now while we're on this topic. I think that's in volume 4 of the authorities, tab 49. And the MS number, the paragraphs are, 21 and 22. The MS number for 21 to 22 are 1533 to 1534.
15.
Yes, MS 1533 to 1534. And it is in those paragraphs that there is a discussion that the correct approach should be that summarised by Lord Reid in Bank Mellat. So I say that still stands as binding authority and a revisiting of the proportionality assessment from Rasgar, which originated with De Freitas, and I would say added on in Rasgar and Huang. We can see the fair balance test added to the fourth or final limb of those questions, and of course was refreshed and revisited again in Bank Mellat and approved. So those are binding authorities of the correct approach to the convention and proportionality. I apologise if I'm going over points that have already been mentioned in the previous appeals. Moving on from there to, well, before I move on that note, it is important to note what Lord Bingham said at paragraph 6 of Wang, and Wang for refreshing the references is at volume 2, tab 18, and the MS number for paragraph 6 is, give me one moment, uh, 673 through to the top of 674, just at the end there. And I would rely upon the final sentence at the bottom of 673, because it's something that the Secretary of State draws attention to in her supplementary statement of case, that if an applicant fails to meet the rules, it doesn't matter because the rules don't need to be compliant with Article 8. I say firstly it's something not to show off about, but I would also say that this sentence is pertinent as if an applicant fails to qualify under the rules, that's the point at which to begin, not end, consideration of the Article 8 claim. and the terms of the rules are relevant to consideration, but I underline these final words, they are not determinative. And by stating that one has to meet insurmountable obstacles, and then when considering exceptional circumstances, it must be something more severe than that, that means the rules are determinative, and in fact, gauge or calibrate how you approach proportionality, which entirely contradicts paragraph 6 anyhow. If it were a convention-compliant calibration, that would be one thing, but it's not, because I've already shown that EX1B does not marry at all with the Rodriguez passage at 39.
One of the difficulties for the Secretary of State is that something that's emphasised in Wang and other cases is the need for a fact-sensitive assessment in the individual case. But the Secretary of State's officials are having to process an enormous number of cases, and it's understandable that there's a desire to adopt a consistent approach. And I think the argument may be, or might be, that that the rules endeavour to give to encourage a consistent approach, which will be applicable to a considerable number of cases. And it's unobjectionable if that approach isn't exactly in conformity with Article 8, provided there's a safety net.
Yes.
Which is the issue then may be about whether the safety net is adequate or not, but that's a function of the exceptional circumstances provision. I think that might be the argument.
That is the argument, in fact, I think that the respondent is pursuing. But the problem she faces is that there is no evidential trace of proportionality or the structured approach to proportionality in her guidance, which is what all caseworkers will go to when they are considering proportionality. So the submission she makes in her supplementary statement of case that proportionality exists in our residual statutory discretion, and it appears, of course, in the guidance which calibrates that discretion, is completely erroneous. If it were there, alongside, I would say, a rectification of the schooling given to caseworkers, that this is what's justifiable, this is what insurmountable obstacles are, because, of course, you will need to rectify their mindset before they even approach proportionality in exceptional circumstances, because they've been taught the wrong thing. They've been told a version of Strasbourg which flies in the face of domestic authority and which is completely unlawful. So if you're going to indoctrinate them in one way, you need to wipe their mind in a Burgessian way, as it were, before they can even begin the exceptional circumstances consideration.
I think you might also want to say that while, of course, it may be legitimate to give guidance in order to achieve a coherent and consistent application of policy, if the exceptionality is a safety net, it must not be expressed in extreme terms, which are, if not incapable of fulfillment, extremely difficult to fulfill, because that is not an effective safety net.
Indeed, my lord, yes.
I think earlier this morning you said, but really didn't elaborate on, something to the effect, well, this test of exceptional circumstances and insurmountable obstacles, it wouldn't just apply to the precarious case. If you did say that, would you like to give us some examples of non-precarious cases to which these twin tests are applicable?
Yes, my lord. My lord, I gave a very short example, but I'll expand upon that, I think, as it may not have been particularly clear. If, for example, one has a spouse one meets in a third country, they apply. I'm going to use the female gender because I'm talking from my perspective. If she applies for entry clearance and meets Appendix FM when she comes to this country, but supposing after 2.5 years, when her visa comes for renewal, I've lost my job, or my home is overcrowded, or she has not passed on this occasion her English language test, but it's more likely to be something in the terms of the maintenance requirement is something that can completely change any day of the week for any people, anyone, particularly in times of austerity. If that changes, that means the eligibility criteria are not met. That means you need to show EX1 is met to still obtain a continuation of your lawful status as a settled migrant.
So the operation of the rules after the entry, sometime after the entry, can recreate precariousness.
Yes, it can, even if you're not precarious, because Strasbourg defines precariousness as someone who's either entered illegally or has overstayed their visa or is being expelled for deportation reasons. Those are the entire ambit, as it were, of the Strasbourg jurisprudence that's before you in these authorities' bundles.
Mostly, I had thought that when Strasbourg was talking about precariousness, it was basically talking about entering into a relationship at a time when your immigration status was precarious. And your point is that in the example you've just given, they entered into the relationship at a time when they had every reason to suppose that they would be able to meet the eligibility and other requirements and suitability requirements. They did. So somebody comes and then the circumstances change, and when their visa's up for renewal, they no longer meet it. And yet they weren't precarious in any sensible sense of the term, because they formed their relationship at a time when they had reason to suppose that they would be able to meet it. And therefore, this approach to precariousness is almost saying it's anybody who isn't a citizen or a settled migrant.
Yes.
Basically, anybody. Because by definition, they need continuing leave to remain, and therefore they are to be treated as precarious.
Anyone who falls
Is that
out
what
of
you're
the-
saying? Something like that?
That is exactly what I'm saying, but in a far more concise way and comprehensive way. Anyone who falls out of the system becomes precarious, because they have to meet EX1. But that's not what Strasbourg says. Strasbourg says you assess it, of course, based on when they entered into a relationship. Were they precarious then? So, again, that's another reason why the system is flawed.
Well, the guidance that you've now shown us does perhaps at least take the caseworker to the difference between those two situations, does it? I'm looking at MS 3276 and 7. It's in your supplemental or additional documents, internal pages 56 and 57. The numeration of the paragraphs may not help very much, but it's 3.2.8, exceptional circumstances. Now, this is exceptional within EX1, is it?
Yes. My lord, I say this supports my point, because, as it says at the bottom of 56, if the applicant fails to meet the rules, you must go on, of course, to consider exceptional circumstances, but a case is not exceptional for missing the rules.
By itself isn't good enough.
That means yes.
At least isn't automatically good enough. But it does it perhaps distinguish on the next page between precarious in the sense of, my lady just used it, and as it's used by Strasbourg, in other words, a relationship formed when you no right to stay, and the other kind of case that you've mentioned, where you say they become, in inverted commas, precarious because of a subsequent change in circumstances. Look at A. Did they form the relationship at a time when they had no immigration status, or this was precarious?
Yes.
So that, I suppose, at least takes the caseworker towards the relevant question, does it?
It doesn't, because sadly they still have to go through EX1 and that Dante level before getting here to exceptional circumstances.
Right.
The added difficulty is this could quite simply be seen as double counting. You're precarious under EX1 and you're precarious again here, in case you missed the point that they were precarious earlier. Just remind yourself that they're precarious again under exceptional circumstances. So it's there are many ways of looking at it, but if they've already gone through the EX1 exercise, they were already given the inferior treatment anyhow. So it is something of a saving grace, but not much of a grace. There was also recently put in I understand it was put into the authorities or the various appendices, some statistical analysis, as it were, of the decisions or the outcomes of decisions in the 10-year migrant cases, because it would be a 10-year route if you are an overstayer. I'm not sure if those have reached the panel yet or not, but if they haven't, I can always refer to them later, after the lunch agenda.
Electronically overnight.
We brought hard copies if you'd like them as well.
Thank you, Ms. Giovanetti. Thank you very much. Thank you.
Thank you.
Thank you.
The short point and submission I would make is that if one looks at the total figure since the new rules have come into force against the total number of those who've succeeded to show exceptional circumstances, it's clear that only 2% of applicants have succeeded.
Now, hang on. Is this the proportion of people who ask to be treated exceptionally, or is it the proportion of all the spouses, parents, and other dependents who are admitted?
It would appear to be, from paragraph 6, and I can only take this as being gospel, that it's a total number of the applications resulting in a grant outside the immigration rules on Article 8 grounds.
That's it.
So it would seem to be exceptional circumstances.
Yes, but the previous figure is all the dependent relatives or partners,
Yes,
isn't it?
all the partners, yes.
It's not a number of applications to be treated as exceptional.
No, it's all those
Take the
under...
2015 figures, the 40,000 figure in the last box on the right and paragraph 5, that's all the partner, parent or private life
But it's all applications
applicants.
under the 10-year route.
Yes.
Yeah.
Which is, the difficulty is that this could actually include people who are not precarious, but those who've fallen out of the system. So I'm just using it as a very vague illustration of the percentage of success rate is 2% roughly.
Well, it's 3%, in fact.
Thank you, Madam. 3% then.
2.8 over 95. But the point's the same.
Yes, but 3% then. It's still fairly exceptionality, I say, is demonstrated by the figure.
If you stay here under insurmountable obstacles, is that a 10-year route?
Yes, it is, because you would only go to EX1 if you fail to meet
Right.
part of the rules.
I mean, that's part of the point about the current rules, that if you fulfil the suitability and eligibility requirements, you come on the 5-year route, whereas if you don't and you have to go to EX1, you're on the 10-year route,
Yes,
which is obviously a very different proposition from being on the 5-year route to settlement. And then, of course, it's the proportion of those on the 10-year route that are then looked at outside the rules that these figures are to some extent showing.
Indeed, my lady, that's correct. So before I leave this topic then, the final submission I would make is the statement of intent. I do not ask the panel to turn to it, please, as I'm quite far behind with my submissions. The statement of intent says at paragraph 11, the immigration rules will reflect all the factors which, under statutes and case law, can weigh in favour of an Article 8 claim. I say that's clearly wrong. I will turn as briefly as I can, although it's a fairly important topic, to the positive and negative obligation argument. At the paragraphs 32 to 34 of the statement of case by the respondent, the first statement, this topic arises. In short, I would say that the removal of a non-settled migrant not constituting an interference with their family life simply is non sequitur, because the whole point of the convention is it's a right to respect for one's family life, and the search for interference is the same as a lack of respect for family life. They are one and the same thing. And I say that, skimming ahead somewhat in my submissions to paragraph 18 of Lord Bingham's judgment in Wang, because he used those two categories in the same breath. The interference or lack of respect is of sufficient seriousness to engage Article 8. So the search for one or the other is a false exercise, we would say. And at any rate, a submission I promised to return to earlier was that of Abdulaziz, which gave rise to this whole argument. But Abdulaziz, paragraph 67, which again, please do not turn to at the moment, discusses relatives of settled migrants. So in other words, Abdulaziz concerned relatives of persons who were not precarious, which is an important distinction to make when one is saying that the positive obligation should apply to those who are here precariously or non-settled migrants. So there is a flaw in the very origin of the argument itself at 68 by looking at 67 of Abdulaziz. I would also rely upon the judgment of Lady Hale in Beebe at paragraph 26. Again, I'm not going to turn to that. I think I've already cited it in my statement of case. I would say it's an important distinction to make, though, from jeunesse, that, which is one I've already made in part, is that in jeunesse the parties entered into a relationship when... Forgive me one moment. Yes, in jeunesse, the parties entered into their relationship before they entered the member state. An important distinction is, and this is a factor which occurs in the line of authority that the respondent praisinates, such as Rodriguez and Nunes, etc., is that that authority relies upon the fact that the precariousness was present before entering the member state, whereas here, the relationship was entered into after entry was secured lawfully, I should point out, in the member state, albeit they've become overstayers, but they did not surreptitiously enter to continue family life and remain as illegal entrants, and those who did not have leave at all. So that's an important distinction to make there.
Sorry, is that a submission that these relationships were formed when the new arrivals were here lawfully?
Not when they were here lawfully. They were overstayers. I accept that in the Strasbourg sense they were precarious at the time.
Right. Is there any case law that makes that distinction that you're making now?
There is no case law that makes the distinction, but the authorities the respondent relies upon are factually different in that respect, in that the precariousness was there from before entry to the member state, it seems.
Why, as a matter of principle, should it make any difference?
Well, I say it makes a difference because if one considers the enumerated interests of protecting one's borders, the protection to the border on entry is probably the most important part of immigration control. If the border is, for that enumerated reason, to be protected when someone enters illegally and has, as it were, deceived or secreted themselves into the country, that is an important factor which doesn't go against the appellants in my particular appeals, because they have secured entry lawfully.
If you're allowed over that border for a specific purpose and a specific time, and then you exceed it, is there any difference in principle about the abuse of the system?
I say there is a difference in principle if it can be shown that the person entered purposely say, for example, on a visit visa, to reunite with their family, then there can't be a distinction. But those are the facts of jeunesse. She entered on a visit visa to join her partner instead of applying for a residence permit. So the point is, if she deceived the equivalent of the entry clearance officer in Netherlands, that is an important point that would go against her, because it's one of the enumerated reasons why the state's interest would go against that, so to speak. But that's not this case.
So in two parallel cases, one enters with a view to joining somebody she's already met, yes?
Yes.
And the other enters as a visitor without such ulterior motive, but then meets somebody. Which has the stronger Article 8 case on your argument?
Someone who enters lawfully and does not deceive the entry clearance officer or equivalent.
You say the first would have deceived the entry clearance officer?
Yes. They must have, unless the intention of their visit was not truly to visit. That is the distinction I draw, because one of the reasons given in the immigration rules is that you are a genuine visitor. If matters develop thereafter, and you stay for different reasons, for example, in Miss Ikuga's case, she applied for an extension of her visa and underwent medical treatment in hospital, which she fully paid for, and was not subject to the NHS. That was a valid reason to seek an extension, which she in fact succeeded on appeal to the tribunal, but she failed to gain further extensions. So there's a stark contrast there to be made. I should also say that this is something that the court in jeunesse were apprised of, because it's mentioned at paragraph 101 of the Strasbourg judgment. Turning then to the fair balance originality or origin of the concept. In my submission, just as the respondent has prayed and aid a line of authority showing that there is a distinction to be drawn between positive and negative obligations, I would also pray and aid a line of authority, a very long line, showing that the result should be a fair balance. And this starts with the Strasbourg decision in Gull, which is contained at, again, I will give you a series of cases and references. I will hopefully have time to turn to them if I may, but if not, then I will move along, but at least you'll have the relevant passages. So it's first Gull at paragraph 38, and also of interest is the dissenting judgment of Judge Martins.
What's the reference?
The reference for Gull is the appellant's additional documents, and
there's a very interesting dissenting judgment by
yes.
Judge Martins saying we've more or less assimilated positive and negative, etc.
Yes, that is where the distinction between positive and negative first went awry, if I can put it that way. My Lord, Gull is at...
I would have thought you thought it was a good idea.
Forgive me?
If the distinction between positive and negative has been eroded in practice by the Strasbourg court,
that's
message by Judge Martins in Gull, I'd have thought you would have thought that was a good thing, not a bad thing.
Not the distinction itself, though.
What you find is the good idea, what you don't like is the majority rather than the...
Well, I'm starting with the history, as it were, of the concept, which has now become prevalent in the majority judgments. So that is at MS, so appellant additional documents, MS 3432 to 3433, and the dissenting judgment, paragraph 7 to 9 of which I'd ask you to look at, is at 3441, MS 3441. In fact, whilst the authority is open, it does make sense to just to look at the paragraph in question because it is replicated in the history of what I will briefly outline. So at 38 on MS 3432, the familiar line appears that if a person refuses entry where their close family resides, forgive me, one moment. Oh no, forgive me, not 38. Yes, 38 recalls the principle from Abdulaziz at 68. And I do apologise. I meant to refer you to Ahmed next for the passage in question. Apologies. 38 recalls the Abdulaziz principle. 7 to 9 in dissent is the departure from that. It was 3432, but I'm closing that and moving to the next authority, which is Ahmed.
Do you want 3438? By any chance? Paragraph 38?
The reference you gave us was to the Commission.
It was the Commission's.
Oh, forgive me. I'm sorry. Yes, 3438 is what I was referring to. That the boundaries between the obligations under the provision do not lend themselves to precise definition. That paragraph is replicated, as it were, in all of the authorities I will direct your brief attention to before the lunch adjournment. And those are the decisions of Ahmut, A-H-M-U-T, not Ahmed, but Ahmut, and that is at paragraph 63, and Ahmut appears in the authorities at volume 6, tab 61, and the MS number for the beginning of the judgment. I apologise, I can find the specific MS numbers over the lunch adjournment, but the beginning page is 2068, which repeats that principle. Interestingly, the next authority in the bundle at tab 62 of Bulteef, albeit it is a settled migrant expulsion case, also raises the principle in paragraph 47 that there is no distinction, as it were, in practical terms between the two. The effect should be fair balance. So that is in contrast to the Secretary of State's case, where it's said that the Rodriguez-Nunes line of authority is distinct from Bulteef, Uner, Maslov. They are one and the same, as I'm going to point to here, and they both have the same paragraphs.
Well,
forgive me.
Jeunesse, the court does expressly distinguish the Bulteef line of authority from the situation it was concerned with in the instant case. It points, it's paragraph 104, 105. They make the point that Bulteef, Uner, Maslov are all concerned with people who are lawfully resident in a contracting state and were being expelled from it. And they say that the different element in a situation where somebody is seeking leave to enter a member state, contracting state, is that immigration control is engaged as an aim of the measure.
My Lord, my understanding of the Jeunesse judgment was that it was simply a replication, as it were, of what has already gone before in Rodriguez, in saying that there is a distinction to be drawn between the two obligations. But the obligation, in terms of the positive obligation respect, is not said to merely apply on entry, but also to those who are here precariously in country, which I say is highly controversial because it contradicts the fact of one having to show interference or the lack of respect for family life. They are one and the same thing, I say.
But wouldn't you say that there is, actually, whatever you say about refusal of entry to somebody who isn't here, making somebody who is here go in circumstances which will interfere with their family life established here is an interference?
Well, it is in practical terms, because their family life is being interrupted more directly on a day-to-day basis than if someone were living in different countries.
The refusal of the permission to set up a family life here may be positively, may be a failure to meet a positive obligation. But
it may be.
Disruption of a family life which has already been established here, whatever the circumstances, would you not suggests that that is obviously an interference.
My lady, I say yes, it's common sense.
We might need to look at jeunesse. I think in paragraph 105, they say that it would apply even in a situation where a person had been unlawfully resident in the host country.
I'll turn then to jeunesse immediately, because it's paragraph 106 that I say contradicts that. And jeunesse is at volume 6 of the authorities. And tab 76. And 105 appears at MS 2453. And I take my Lord's point of what paragraph 105 says, but it must be read in accordance with the relevant principles then defined at 106, which mimics entirely or repeats the precise passage that I referred to at 38 of Gull. So we can see the genealogy of this paragraph goes all the way back to Gull, which was, of course, an expulsion case. It intermixes with other authorities such as Armut, Bulteef, Konstantinov, Uner, which I'm going to give paragraph numbers as well for, to make good my submission. My lady's point, of course, is a common sense one, but I'm seeking to take a more aggressive stance, as it were, in terms of showing that the fair balance test is what wins the day in Strasbourg's clear and consistent jurisprudence. And ultimately, my submission will be fair balance chimes with the final step of Razgar and is, for all intents and purposes, a proportionality assessment of all factors. If I can briefly give those paragraph numbers, or if possible, I can hand those up, give a note perhaps over the lunch adjournment or before the close of play. The authorities are Konstantinov at 46 and 53. I will give MS numbers and volumes shortly. Uner at...
Just give the tab number, we'll be able to find
very well. The tab numbers for Konstantinov are tab 64, and the paragraph is 46 and 53. The next tab is relevant, is Uner at 65, and the paragraph is 43. Then comes tab 66, which is Rodriguez, and the paragraphs are 39 and 44. Then tab 67 is Maslov, and the paragraph in question is 76. Then tab 68 is Y versus Russia, and again it appears at 103. Then moving to Arvelo Aponte at 71, tab 71, the relevant paragraph is 53. I wanted to take the panel to that specifically because it does discuss it in some detail.
All right.
And then Butt versus Norway at tab 73, and the relevant paragraph is 90. Bial versus Denmark at tab 74, and the paragraph again appears at paragraph 52. And then tab 75, Nunes versus Norway, and the paragraph in question again appears at 68. And finally, jeunesse at 106, the paragraph appears again. And most recently, the authority promulgated the other day, just in the last week, I think, by the Strasbourg Court of IAA versus the United Kingdom. That's in the Appellant's additional documents at item 12, and pages 357 to 369. And the relevant paragraphs there are 38, 40, 42, and 47, which discuss the fair balance approach. There is also reference in my in the other authority in the additional documents of. I'm conscious that I might be over-egging the point. Evans versus the United Kingdom. That's at 255 to 282, and the paragraph in question is 77. And finally, and this is the most pertinent authority I'll refer you to, it's Aksu versus Turkey again, in the appellant's additional documents, and the page numbers are 333 to 356. The paragraph in question is a fairly long exploration of fair balance, and that is at 62 all the way through to paragraph 68. So that seems to be the largest exposition, as it were, of the fair balance approach, but which ultimately favours fair balance as opposed to noting a distinction between the two. So, for example, one can see that the same paragraph from Gull and Armut appears in the Jeunesse judgment at 108, as I've already pointed to, and 106, sorry. And so on that basis, one can see that the history of the phrase from 1996 through to 2016 has consistently been, over 20 years, fair balance. This, at any rate, notwithstanding all of those handsome submissions, this accords with the judgment of Lady Hale in BB, and the paragraphs I would rely upon are 25 to 30. BB is located in the authorities at volume 3, tab 34, and the MS number it starts on is 1236. In particular, I would rely upon 27 and 31, 27 being an agreement that in both regards, negative and positive, a fair balance must be struck between the competing interests. And also at 31, that whatever the states might say on their different concepts of family, whatever their concept, it must be afforded the protection required. So I say that the family unit clearly must be afforded protection. There's going to be a practical interference. Strasbourg has said for 20 years there needs to be fair balance. The distinction has always been defeated in all of the authorities referred to by the respondent by a subsequent paragraph stating fair balance. I would also, just before leaving BB, in particular highlight 29, wherein, notwithstanding the analysis of the Strasbourg authorities by Lady Hale, it said that fair balance is something that we have followed in this country since Huang and Quiller in conventional proportionality terms. And I say that conventional proportionality is the catchword here. It is precisely what is missing and what should have been present. And that is why the decisions are not open to the Secretary of State to make.
Well, that's a very good point on which to adjourn, I would have thought, before you move on. How are you doing? You've got another quarter of an hour.
My lady, I am halfway through. So if I may...
well, you could have a discussion with Ms. Giovanetti about
discuss it with Ms.
timetables, but basically, we have heard all of this before.
Yes, my lady.
I don't think you have said anything that hasn't been said in a previous case, although you have said it rather differently.
Yeah.
So do not think that if you're not able to get through everything that you've got in your speaking note, we are not going to be aware of the points that you wish to make, because you have already produced an extremely long
yes, I do apologise
written
for that.
case. So, in other words, don't feel bothered. Just pick out now from what you've got left the really important points that you have to make.
I'm grateful, my lady.
I'm sorry, I'm
do
trying
that.
to help.
No, you are. My lady's being incredibly gracious and helpful.
Well, we'll look forward to hearing from you again at 2:00. Thank you.
Thank you.